Good morning, Champion School of Real Estate, amazing students and friends and teachers and staff. I'm Rita Santa Maria. I'm the owner, founder of Champion School of Real Estate. And I thank you so much for joining us today. We so appreciate your business. One of the wonderful things that we do for our students is to bring you free opportunities to help you be a better, more successful agent. And so generally, as you know, once a month, we interview top agents in residential and commercial real estate. On January the 8th, we will have Dr. Gaines here giving us the economic outlook for 2020. Today, I have one of our students, but a very fine real estate attorney, David Willis, that is joining us to help you on the legal side. But before we get going, David, I want to do a shout out to our Plano campus in North Dallas, to our Fort Worth campus right off of Camp Bowie, certainly our beautiful new Austin campus. Hello, Austin. And that is where the president of our company resides, Kimberly Didelowitz. Hello, Kim. And then we have San Antonio. We absolutely love our San Antonio location, our staff there. We just think people in San Antonio are just happy. My teachers go, what do they do in San Antonio? They're always so happy. They're always celebrating. We have our wonderful 3 campuses in Houston. We have the West Campus in the Katy area, Highway 6. We certainly have the Galleria campus where I am today. Hello, Galleria. And then we have the North Campus, and we will be finishing up that new building in June and moving in June, right at the Grand Parkway and Kirkendall. We're so excited to relocate from our 1960 location to a newer, more beautiful spot, because our goal is always to make your classes, when you're in the classroom, very comfortable and state of the art. So thank you all for being our customers and allowing us to grow. Without your business, we don't have one, and we say that all the time. So today I brought in one of our Houston area, well-known Texas real estate, double board certified attorneys. And David Willis is a member of the Texas Bar since 1980. He's board certified not only in residential real estate law, but also commercial real estate law, and has his real estate broker's license, which adds a lot more fun to our discussion because he understands brokerage as well as being a very fine real estate attorney. He's written numerous articles, and I have to tell you that his book that we have on our flyer, Real Estate Law and Asset Protection, this book right here that was and is on Amazon, I know after today you're going to want to order his book. It is a great reference book for all in real estate. But this morning he brought in the new book. This is the 2020 version. And in fact, he said, Rita, put that away. That is not up to date. That was 2018, which shows you how very good he is about staying up to date. So Real Estate Law and Asset Protection, the 2020 edition, you can get it on Amazon, Barnes & Noble, and it is a fine, fine book. But I'm just proud to say, David, you're one of our customers, and I thank you for that.
Well, thank you for having me. It's always a pleasure to be back at Champions.
It is our pleasure. And of course, Alan Hancock has known David Willis for a long time. And Alan said, when I told him I want to go a different direction in the fall and get some good information to help keep us out of trouble. And he said, well, I know who you need to talk to, David Willis. So thank you for being here today.
Thank you.
So I'm going to start right away by just saying, let's find out a little bit about you. What do you like to do in your free time, or what is your hobby, or what might you do that would surprise us?
I think my hobby is mostly reading and reading about future trends. And this is what Alan and I have in common. And Alan, if you're listening, I have a new book for you. It's called The Sixth Extinction by Elizabeth Colbert. She's a science writer for The New Yorker. And it's about the 5 major extinctions that have occurred on planet Earth and the possibility of another one in the not too distant future.
Tell us the name of that book again, because you already have about 50 people.
That's called The Sixth Extinction. Elizabeth Colbert, Kolbert.
Well, he will have that probably by end of day today.
Probably.
Knowing our Alan. And then what might have been your first job that you had?
Well,
as a young man or whatever.
I've always been athletic, and I started out teaching tennis and swimming.
Okay.
But that was
swimming
in college.
So what gave you that? I always like to use the word defining moment because everybody has one. What did you decide, or when did you decide rather, to go into real estate law?
Well, I've always felt that one's specialty in life, or certainly in your profession, more or less finds you rather than the other way around.
Okay.
You might start off in a certain direction, but you'll find that your early jobs, your early business engagements will lead you in another. Mm-hmm. And that's what happened to me. I didn't so much choose real estate law as it chose me. And the more I did it, the more I liked it.
Good. Well, the cool thing about your book is it's all about Texas real estate law.
Right.
And the name, Real Estate Law and Asset Protection. We have a lot of new people watching today from Plano, Fort Worth, Austin, San Antonio, Houston, as well as our live broadcast that you saw today. So when we talk about asset protection, what are we talking about? What are our assets?
Well, that answer varies from state to state, but in Texas, we have a list of assets that are exempt from judgment execution. These are very different and much more thorough than other states. Your home, for instance, your retirement plans, certain life insurance plans, a long list of personal items as well are all exempt from execution on a judgment. So it's not uncommon in my law practice to find people from other states who have large judgments against them, for instance, from California. This happens all the time.
And that's where you went to college.
I went to law school at USC, yes.
Right.
And I got a second law degree at
University of Houston.
But California doesn't have those kinds of protections, for instance, and so someone in California may get a very large judgment against them, and they move to Texas to take advantage of our homestead protections here, which are very substantial.
You want to talk about those for a little bit?
Well, the primary one, the king of the exemptions in Texas, is of course the homestead, and there's no upper limit. You can have $1 million or $10 million house, and a judgment creditor cannot force its sale.
Exactly. And that's what we love about our homestead protection.
All right. You have to keep in mind there's a slight difference. People talk about homestead exemptions, and on the one hand, they mean the tax exemption that you get with the appraisal district. That overlaps with and is similar to, but it's distinct from the homestead protections that are found in the Constitution and in the property code that protect your assets in the event someone has a judgment against you.
Mm-hmm. So you can't lose your home.
You cannot lose your home unless you're very foolish with it.
Exemptions. Yeah. What are the exceptions to that? And we're all learning this if you're new people, but just a little reminder.
Well, Texas doesn't give you a blank check in these regards. I mean, you do have to do it in the ordinary course of business. That's the phrasing in the property code. If you transfer assets around or you move assets in order to avoid execution on a judgment, then that can get you into trouble. The courts will possibly look at it and consider setting it aside. They can go back up to 2 years to do that.
Now, I know that you very much specialize in forms of ownership. And in your book, you talk about LLCs, LTDs, corporations, Certainly, we have sub S corporations as well as the court. But would you give us an idea of the difference between an LLC, and students, be sure to write this down, get it in your notes. You'll love having this straight from David. The difference between an LTD, an LLC, corporation, and you may not want to answer this, but if you could recommend to our entrepreneur students what they might do to protect their assets, what they might do.
Well, in years past, the corporation was the dominant form of registered entity. That has changed over the last 20, 25 years. LLCs dominate now.
And what does that stand for?
Limited liability company.
Okay.
And if you check with the Secretary of State of Texas, you'll find that the filings for LLCs now far exceed corporations or limited partnerships.
And why?
They have the benefit of more informal management.
Okay.
They're more suitable for a small business, perhaps consisting of mom and pop or a handful of investors.
Okay.
They require less in the way of paperwork and documentation and formalities. They don't have to have a board of directors, for instance. So it's a registered entity with a liability barrier, but there's no requirement that you maintain it by doing all sorts of paperwork.
Yay!
And so you can operate informally.
Good.
And so it's become much more popular, and that's really the dominant form of entity for real estate investing now. Corporations are really only used anymore if the intent is eventually to take the entity public. And limited partnerships, these are more common in commercial investments. So,
Okay. So a limited partnership, that's also going to protect my liability.
it does.
And what entities must it have within the limited partnership to make it a limited partnership?
Well, first, let me start with saying the best kind of limited partnership is a partnership of entities.
Okay.
Oftentimes, you'll see limited partnerships, or I do, that are formed by individuals.
Mm-hmm.
And it's not good because even partnerships, they're a registered entity, they have liability protection, a limited partnership does. But, you know, if you're in there in your personal capacity, it's possible you're going to be exposed. So the best kind of partnership or limited partnership is a partnership of entities. Now you can have limited partners that are limited to the extent of their contribution. If they put in $50,000, for instance, that's all they can lose if the partnership doesn't work out. There is a general partner, however, that is typically a corporation, and it's a shell, and the general partner is charged with managing the partnership. So there's a distinction there. The limited partners are limited in their liability, but they cannot engage in management. If they do that, they lose their limitation. So that has to reside and continue to reside exclusively with the general partner. So, I mean, there's a lot more structure to that. It's more typical if you had a group of investors buying a large shopping center or something like that.
Okay. And if you had a large group of investors wanting to buy a shopping center, they're going to form an LLC, or they already have an LLC, and they're going to bring in an LTD. Is that correct?
Yes, that would be certainly a good way to do it.
Okay.
A very common way to do it.
I just have to say, there are so many people right now going, now how can I capture this and rewind it so that I can keep learning and remembering what I learned? And the answer is, by tomorrow, this will be on YouTube. And everyone will be able to watch it again on YouTube, just to let you know, because this is really very important for our real estate loan appraisal and inspector students, because they're all independent people and entrepreneurs. So would you, and if you don't want to answer it, fine, because I know you're an attorney, but if I came to you and said, I'm a real estate agent working for XYZ brokerage, do I need to form some type of personal business entity to protect myself?
Probably not.
Probably not.
Not unless and until you start investing in real estate yourself.
Which everybody likes to do.
Well, I think most people enter this profession with the idea that they're eventually going to do that.
Sure.
So once you do get past the individual level where you're protected already under Texas's very generous homestead laws, Once you start acquiring non-homestead investments, rental houses, and so forth, then you don't have the benefit of those exemptions anymore. Those assets are exposed. So at that point, you want to consider forming an LLC for your investments.
Perfect. Good. So do you mind, let's bring it sort of into day-to-day practice for a little bit. And our experienced agents, as well as our new people in the classroom, they're learning about DTPA, Texas Deceptive Trade Practices Act. And I would love for you just to give us your overall, I want to say, definition, what you think we all need to be aware of on a day-to-day basis. So DTPA, can you help us with that?
Well, the Deceptive Trade Practices Act is designed to prevent exactly what it says, deceptive acts in commerce. And it applies to consumer goods. And there was a question many years ago about whether or not real estate was in fact a consumer good and fell under the DTPA.
That's right, I remember that.
It's been many years since that was resolved.
Big discussion.
It is a good, it is a consumer good, and all those engaged in real estate are working with this consumer good and fall under the possible penalties of the Deceptive Trade Practices Act. These are very broad. Essentially, if I had to sum it up in a single phrase, you should disclose to a buyer anything that might affect that buyer's decision to buy or not buy. And that's a pretty broad standard.
It is.
And we do, of course, have a seller's disclosure that we attach to the trade contracts. But it's a little iffy on how much the seller is standing behind that. If you look at the top of the disclosure, it says this is not a representation or a warranty on the part of the seller.
It does say it is not a warranty for sure.
So those of you who are representing sellers need to caution your seller, your client, that even though it says that, and it seems to be kind of a loophole, don't treat it that way, because the Deceptive Trade Practices Act will apply, and your client will be held responsible for anything that he knew and should have disclosed that might have affected the buyer's decision to buy or not buy.
And another side of that being, as an agent, if there were a lawsuit under DTPA or a lawsuit under non-disclosure, the fact that you got the seller's disclosure and had that signed by the seller where he or she didn't disclose something.
In his or her handwriting, hopefully, not yours.
In his or her, for sure, his or her handwriting.
Right.
That does help the broker. It does help the agent.
Yes.
On a defense side.
Real estate professionals are exempt under the DTPA so long as they don't have knowledge.
Right.
All right. Now, cases have held that if you, for instance, pass an inspection report that has something to do with termites, for instance,
right,
you pass that to the buyer, but you didn't read it, you're still not held liable for that. But as soon as you know it, then you've got a problem. So if you're working with a seller client that is reluctant to disclose key adverse conditions, defects, circumstances, anything again that might affect the buyer's decision to buy or not buy, then you need to advise and counsel that person that there's liability not only for them, but for you.
Exactly.
So as soon as they tell you about it and you have knowledge,
exactly,
and your seller client doesn't want to disclose that, you need to get out of that arrangement.
And just a really good point from that I want to make sure everybody heard. And that is, even if the seller doesn't disclose it, but you have knowledge of it, you are obligated to disclose as the real estate professional. And as well, those disclosures are always signed and filled out by the seller, certainly not the agent.
And it's not just the Deceptive Trade Practices Act. We have ethical obligations under the Administrative Code.
Right.
And in the Real
That
Estate
would be
Licensing
the
Act.
Real Estate License Act.
In the Occupations Code. And those of you who are members of the Texas Association of Realtors, there's also a code of ethics there.
Code of ethics.
And I think that code of ethics makes it even more clear that maximum disclosure is called for. So if I had to give one piece of advice for sellers, it's disclose, disclose, disclose.
And that's excellent advice. And that being said, as an attorney and helping people, and I'm so glad you're one of ours in the Houston area. And I know agents definitely will say, what was his name again? I really need to put him on my list of fine real estate attorneys. But are there any examples of something that an agent might have done where they didn't disclose and they had a problem?
Yes, I've seen several cases where agents and brokers get into their own investments. And of course, as we discussed earlier, that's what they all want to do eventually.
Uh-huh.
But you need to disclose that you are, in fact, a real estate license holder, that you are a licensee engaged in this transaction on your own account for a profit, and that the person you're dealing with is neither your customer nor your client. You should go on to tell them or advise them to consult a real estate professional.
Exactly.
This is an important disclosure that is often left out.
It is, and most definitely for those that are investing on their own behalf, buying and selling on your own behalf, that's under the Occupation Code, the License Act, that you must disclose that you're a licensed agent.
Well, here's the problem, you see. If you get into court on something like that, you can be assured that the judge and the jury will hold you to a higher standard than the average person.
Exactly.
Those of us who have been educated in this field, have been granted licenses, either law licenses or real estate licenses by the state, are going to be held to a higher standard. You're not going to be able to use the casual excuse, I didn't mean for that to happen, or this, that, and the
Well,
other.
for goodness sakes, you took 180 hours with Champion School of Real Estate. Then you took 98 more hours for SAE. Now you take 18 hours every 2 years. You should be more knowledgeable.
And you can be sure that the opposing attorney will point that out.
Exactly.
So
Exactly.
that's the downside, I guess, if you're a real estate investor, to having a real estate license. Your obligations are, in fact, higher, and your exposure is therefore higher.
So another practical day-to-day issue that comes up is the earnest money.
Yes.
And just the issue of, okay, the contract falls apart, transaction falls apart, and certainly the buyer wants their earnest money back. The seller says, belongs to me. Can you tell us the ins and outs of the constant earnest money deposit issue?
Well, it comes up a lot. Of course, paragraph 8, I believe, of the TREC contract governs earnest money and its distribution. The problem is people don't follow paragraph 8, and then you're stuck. And the question is whether or not you should institute some kind of legal action to get that earnest money back. You have to be aware that the contract calls for mandatory mediation. That used to be a selection. You used to be able to choose whether or not mediation was.
It's a good point. It is mandatory.
It is mandatory now. So before you rush to the courthouse and file a lawsuit on any of these issues, if you're working with a TREC contract, you're obligated first to mediate. And that can be, well, it can be an expedited process, but oftentimes it can take a while. I've seen opposing sides take 3 months to agree on a mediator. So it's not necessarily a quick process. But that clause does say that it's not meant to prevent a buyer from seeking equitable relief in a court of law. So even though you're obligated to mediate, if you think the seller might go ahead and sell that property to someone else, you're still free to go and get an injunction from a Texas court. And that may,
would
in
that
fact,
be like typically a small claims court based
No.
on dollar amount?
No.
No?
The actual dispute over the dollars and who's entitled to it could be brought in small claims court, so long as it's under $10,000.
Right.
But small claims courts don't issue injunctions. You'd need to be in a district court
Okay.
where they can tell the seller, you can't sell the property while this
This is
going
still
on.
out there.
So you might have to pursue both mediation and a legal action, what they call in the contract an equitable action at the same
So
time.
tell me if this is correct or incorrect. So if I just wanted my money and it's less than $10,000 in question,
Yes.
then I could go to small claims court. But if I want to stop that seller from being able to sell his house, then I would have to go to district court. And
You
get
have to
an
go to a
injunction.
higher court. The Justice Court is very limited in its jurisdiction, up to $10,000, and that includes attorney's fees. So the second that you have a Justice Court judgment for $10,001,
Mhm.
it's void.
Mhm.
So there are limitations there, but it's easier to use. You don't have to have an attorney. There are more and more attorneys appearing in justice court, but for the most part, the rules are pretty simple and you can do it yourself. Anything at the county court or at the district court level, you do not want to try to do it by yourself.
No, you would.
No.
So you work with investors all the time,
I do.
and that is definitely your forte. And I'm really rather curious. We don't talk much about seller financing or owner financing in class because a lot of our transactions are either, frankly, the overriding majority or conventional loans. And we're also very happy to say we have a lot of all cash coming into the transactions on residential.
Always better.
Always better. You don't have to worry about funding as much. But let's talk about owner financing. What are the positives, negatives, precautionary areas with owner financing?
Well, the first thing to realize is that owner financing consists of several different options. There's the classic owner finance where the property is paid for and the seller becomes the lender. And there's a note and a deed of trust. And it's a transaction between the buyer and the seller, and that's all. There are other kinds of owner financing. The classic ones that we've had in Texas for years have been contracts for deed, lease options, and lease purchases. All of these fall under the umbrella of owner financing, but they also fall under Section 5.061 of the Property Code, which defines them to be executory contracts. Now, these are a problem.
Now, what is an executory contract
Well,
for all of our students?
the distinction is between a contract that is executed,
Mm-hmm.
everything is done, finished, it's closed,
Signed, closed.
and a contract that is executory, which leaves something important dangling, something unfinished. Usually the most important thing of all, which is the deed.
Mm-hmm.
It's left undone, therefore that contract is executory, it's not executed.
Executed.
That's the difference. And under the property code since 2005, there are now very burdensome requirements to do any kind of executory contract. And these must be met before the contract is signed. Now, with the usual contract, we're used to signing the contract, and then we have an option period, or under the TAR, we have an inspection period to take
Check
care of
out the
business,
property.
give the seller's disclosure,
Feasibility.
do inspections, appraisal, and so forth. In an executory contract situation, that's flipped. You have to get all of these things done before the contract is signed. You have to provide a survey, a copy of the restrictions. You have to do a lot of things. There's a statutory disclosure that has to be filled out and delivered to the buyer. The other thing important to realize about executory contracts is that the burdens are all on the seller. So even if it was the buyer's idea, it came to you and said, let's do an owner finance, a lease purchase for 10 years, and these are the terms, and the seller reluctantly agrees to it, it's still all on the seller in terms of the legal burden to meet these requirements and the liability for not doing so.
And I'm sure most sellers have no idea.
They have no idea. You should never do anything like that without talking to an attorney. But lawsuits are popping up all over the place about executory contracts. The other thing you need to know about them is
that because we have more investors in our marketplace?
There's-
Especially.
Yes, I think that's probably a big
Okay.
cause. But one important caveat is that to fall under 5.061 and to have to meet all these requirements, the executory contract has to be for longer than 180 days. You know why that is?
No.
Because otherwise, the seller's temporary residential lease wouldn't work out.
Okay.
So the 180-day exemption from executory contracts is there to accommodate brokers who do residential lease.
Interesting.
So if
It's a
you're going to
fine
do it,
point we need to put in our book.
yes.
In
So-
our book.
So if you want to do a lease purchase or a lease option or something like that, make sure it's less than 180 days. Then you won't hit that threshold imposed by the statute.
Do you have any prejudice against lease options or lease to purchase?
Not as long as they're less than 180 days.
Okay.
There is a kind of creative way to take a lease option and stack it. so that it automatically expires and then automatically renews.
Again, you'd want an attorney to do that.
Yes, very carefully. I'm unaware of a case on that, but it's
Uh-huh.
possible that a judge might look through that and say, now the intent of the parties here was really to go beyond 180 days, and so I'm going to call that an executory contract.
Do you think it's better to go lease purchase than contract for deed?
Yes. The reason, I think, on both sides, but particularly for the buyer, is that you get a deed. I mean, you want your deed up front. That's going to be the most important thing. And a contract for deed, that is delayed to some point in the future.
Exactly.
And there's just really nothing better than a warranty deed.
Okay. So let's talk about living trust. What is the benefit and why do a living trust? And what is a living trust?
Well, if you read about trusts and you read about asset protection, then you'll hear about living trusts in that context, but they're really not an asset protection device. A living trust is actually a very good thing, but its primary purpose is to avoid probate. Even though we have a relatively expedited probate procedure in Texas, it's not as long as New York or California, for instance. It still can be something of a troublesome thing to go through. So to the extent that you can avoid it, a living trust will help do that. The trust doesn't die. So in your typical living trust case, you have the parents who are trustees and the children who are beneficiaries. And the passage of beneficial interest is automatic. There's no intervention by a court required. And, in the case of most legal documents, there's a downside and an upside. There's really no downside to living trusts. Most people who have a home and a family should consider getting one. I have one.
And I do too. And I know it was explained to me that it just really sort of expedites the probating or probation of the will, or
Well, it bypasses it
it
completely.
bypasses it completely.
And it's entirely automatic. No lawyers required, no courts required.
So what about wills? Because there are certainly our students sitting in class, I would say maybe 70% of them that don't have a will.
You know what's amazing? Most lawyers don't have wills.
No.
That's absolutely
Well,
true.
obviously you have a will because you have a living trust.
I can neither confirm nor deny.
Oh. That's a good answer from an attorney. But what about wills in Texas and how it affects your property and how easy it is to have a will?
Well, we have an option for a self-executing will in Texas.
Right.
And it's an expedited procedure so long as the will is done properly. Now, the thing that I can't encourage people enough not to do is get real estate forms, will forms, and other kinds of legal documents off the internet. I spent a lot of time with my clients cleaning up junk forms that they've gotten off the internet and signed, and they wind up doing more damage than good. So don't get your will through a lawyer who knows how to do wills. But these tie in also with the living trust. And you probably know this if you have a living trust, because you put, for instance, your homestead into a living trust. So that's taken care of. That's going to automatically shift its beneficial interest to the children probably when you die. But what about those things you acquire in the meantime, or since the time you establish the trust? You need what's called a pour-over will. All right. So what happens is that will collects anything that you've acquired since the time you set up your living trust and pours it into the living trust.
So it's literally POUR,
Literally.
pour over will.
Literally.
Okay.
And what happens then? The assets that are poured into the living trust, they too avoid probate. So the living trust and the pour over will are designed to work together.
So you know I'm going to be on the telephone today.
Well, fortunately, pour over wills are reasonably simple wills.
Okay.
You just basically.
Interesting. But we teach in our class that you want to save some money, but you want to protect yourself in case you were to pass. And so you can do a handwritten will in Texas.
You can do what's called a holographic will. It has to be
Exactly.
in your own handwriting and signed by 3 witnesses. Again, not advisable because our expedited probate procedure the self-executing procedure that we have here in Texas that is reasonably fast requires that you use certain magic words. And you're probably not going to be doing that. If you write will yourself in your own language,
Sure.
it's going to be a will that's going to require the appointment of a personal representative rather than an independent executor. It's going to take longer. So that's really
what are
not
some of those
preferred.
magic words, just for the heck of it?
You have to designate somebody as an independent executor for the male, executrix for the female. And there has to be a self-proving affidavit attached to the will to comply with the estates code. And if you do these things, then your appointment is independent, which means you don't have to go to the court for every single little thing. You can make decisions about how to dispose of property without court supervision. It's a much better procedure, but again, you have to write the will properly.
So we hear in our day and time about hard money lending.
Yes.
And it's thrown out as though everybody understands what hard money lending is. And I would really enjoy for you to explain hard money lending and again, sort of the do's and don'ts and the whys of hard money lending.
Well, you can look at it from the point of view of the borrower or the lender. Now,
let's say, first of all, borrower.
All right, that's good, because that's where the legal risks and dangers lie. Hard money lending is basically a private, unregulated market that doesn't have any of the normal restraints on interest rates or anything else. I mean, the usury rate does apply, but it's typical to see 20% interest rates on hard money loans. You see upfront points, 1, 2, or 3 points on hard money loans. These are private individuals with cash who are lending to real estate investors, most often for a fix and flip. So this is a kind of bridge financing.
And wow, is flipping popular?
It is, but you need the money to rehab the property in order to flip it. And so that's where hard money lenders come in. I see more and more of them coming in from California. They contact me and they say, well, how do I get licensed in Texas to be a hard money lender? Well, you don't need a license. So the market is the Wild West. And I guess my point there is that if you are the borrower in that case, you want to be very cautious about the documents that you sign. You want to make sure, for instance, that there's a non-recourse clause in your note, which means if you're doing a deal to fix and flip a specific house, that lender can take an interest, a security interest in that house only, and not reach out to get your other assets.
As a pledge, more or less, of the money they loan you?
That's called a security interest. That's what a deed of trust does. So the lender is going to take a deed of trust, and you want to make sure that deed of trust includes a clause that the lender's remedies are limited exclusively to that property. You can't reach out beyond that and take your other assets. There are other things that you need to consider if you're a borrower in a hard money situation. You definitely need to consult a lawyer on that one. And again, please do not use forms off the internet. They'll really get you in trouble.
So what is the downside to the lender then?
Well, almost none.
I couldn't think of it.
You know, because here's the thing. In a normal loan, you evaluate the borrower's credit. You appraise the property. You do all kinds of things to evaluate the creditworthiness and the ability of the borrower to repay. In a hard money situation, it's all based on that deal, the house or the project, the dirt. And there's really no deal risk at all. If you run the numbers correctly as a hard money lender, there's really you're going to, it's a win-win.
The only risk would be is that your borrower took the money and went someplace else, to another country.
Well, you can avoid that, but yeah, I mean, it's a Wild West kind of market, and you have to be careful. There's no standardized documents for it. I see documents for these loans all the time, and they're very onerous. So again, talk to your lawyer before you sign anything.
And I brought that up because in the Houston area, there were so many homes after Harvey where people were most definitely hoping that you, the lender, would come in. I mean, you, the investor, would come in and buy it from me. And then we had all these people that have decided that buying and flipping is where they want to be.
There were a
need
lot
to
of
be.
disappointed people during that time.
You got it. And there was a lot of hard money lending going on. And just, at Champion School of Real Estate, we've had people in class talk about how they personally got harmed because maybe they didn't go to an attorney and have any documents drawn up. So I wanted to bring that forward.
And you need to be careful also if you're going to engage in this on either side as a borrower or a lender, if you are a real estate license holder.
Exactly.
Because all sorts of ethical considerations are going to kick in.
Now, what is a shelf company?
Well, for those of us who do entities and establish corporations and LLCs and so forth for investors, many of us will have on the shelf some previously formed companies that are ready to go.
Oh, are these companies where people just didn't need
No,
the ownership anymore?
no, the lawyer will form them.
The lawyer just has them ready to go.
Yes.
Okay.
And he's listed as the organizer and the registered agent and so forth. So it's a matter of transferring and assigning the interest in the company to the client.
I've always been so curious about this. Okay, go ahead.
But you can get a company that is, for instance, aged 5 years. And sometimes that's important, perhaps in Dun & Bradstreet rating or other things.
Okay.
So there are considerations. And if somebody needs something right away, a shelf company is often the solution.
Can you give us an example of that? Why I would need something right away like that?
Well, let's say there's you get a demand letter, a Deceptive Trade Practices Act demand letter.
Okay.
And you suddenly realize that certain of your assets would be much better off inside the protection of an LLC.
Okay.
So rather than wait the time to get
do
this
that.
thing, yes, you can just get one that's already formed, move your assets into it. Once again, you have to give some consideration to the fraudulent transfer rules, but that would be an example where someone is afraid they might be sued.
So what has been one or two or three of the primary reasons that your business has grown over all these years? Can you tell us something about how your business has grown and what's been most beneficial for you?
Well, that's an interesting question. I was doing everything in a very
You're also an independent contractor, entrepreneur.
Yes, I guess so. Yeah. Some years ago, about 8 or 9 years ago, I had some very extensive back surgery. And I started to think about, well, this may impose some limitations on what I'm able to do in the future. So I started to think about how I could pursue my business model a little differently. And I started to expand my website. And that's what I've been doing for the last decade or so. And it's developed into an e-commerce site for law. So you can, in fact, order documents, pay for them online. You can get them within a day or two. You don't have to leave your house or your home. And I predict that this idea of law as e-commerce will expand. We'll see more of it in the future.
And tell them the name of your website.
Lone Star, like the state, landlaw.com. LoneStarLandlaw.com.
Landlaw.com.
Easy to remember.
Excellent. So, if we were going to give a certain example or a couple of examples to our agents that are out there of the most overriding majority of bad things to do as an agent that you shouldn't do, in your capacity as a real estate attorney, what are just maybe the mistakes that agents make that they don't even think about? They didn't mean to do it. What do you see that might help them to maybe at the end of putting the transaction together just stop and think, did I do this? Did I do that? Did I do this? What do you see overriding as an issue?
Well, we've touched on a couple of these points. The first one was in the case where the agent or broker is engaging in the transaction for their own behalf.
Right.
You need to disclose that.
Right.
Aggressively disclose. And another situation would be, we've also talked about where you have a seller client that's not quite willing to disclose all the possible defects in the property. That will get you in trouble in a hurry.
Disclosure.
You can always argue you didn't know, but that argument
You
might
should have
work and it
known.
might not. So the third thing is fill out the entire contract. Don't leave blanks.
Why do agents leave blanks?
I don't know.
It drives me crazy.
If the blank doesn't apply, put NA.
Put
Or if there's a number there and, for instance, for the amount of the homeowner's warranty and the seller's not going to pay anything, put 0. Don't leave it blank. This is what creates ambiguity. And ambiguity is what creates lawsuits. So fill in the entire contract.
Exactly. And as well, we have our addendums that we use during the countering process. And in the old days, which wasn't so long ago, we would make those changes on the contract and then have all parties initial. But there are so many people that just don't take the time, and they should because they're a trick addendum, take the time to pull those addendums and use those for negotiating. And instead, they just have buyers, sellers change it on the contract.
Well, that's legal.
It is legal.
It's a little messy. I mean, you can cross out, you can interlineate, and both sides initial the change. That's legal. But if there's an available addendum for something, you're required to use it. Now, there's certain areas where there is no available addendum. For instance, a wraparound transaction.
Exactly.
Neither TREC nor TAR has an addendum for that. So you're going to have to get a custom wrap addendum from an attorney. And this is generally what you need to think about doing whenever you have a non-standard contract, something that doesn't fit easily within the TREC 1 to 4 and the available addenda. You may need what's called a special provisions addendum, which covers certain items, and it doesn't have to be long or in a lot of legalese. You can just list, notwithstanding the foregoing contract, we agree to 1, 2, 3, 4. And that can solve a lot of problems. But you don't, again, want to leave anything to chance or ambiguity. If you think you have some non-standard terms that aren't covered by the TREC addenda, then get a special provisions addendum. But you're going to have to get that from a lawyer. And just also the wraparound addendum. Wraparounds are very common now. People are using a seller financing addendum for that. No, it's not suitable for it.
This discussion is very similar to what we discuss in our prep class, where we have on the state exam that you must use the state addendum for certain changes. And yet, when you're looking at the question, but what are the exemptions? Yes, it is definitely legal for the principals to the transaction to change and have initialed on the contract itself and not use that addendum. But that's what drives our new people crazy. And the answer is, your broker is probably going to say to you, we prefer you use the addendum that goes along with the contract. But legally, is it acceptable? And it is. It's acceptable.
The TREC contracts are really very good contracts.
They're excellent.
If you've seen contracts
and they're put together by attorneys
at the broker lawyer committee.
Right.
If you've seen contracts from other states, I mean, sometimes they're just appalling. They don't have disclosure requirements. I looked at a North Carolina contract not long ago, and there was no requirement that the seller make any disclosure of defects. I was alarmed. So use the TREC contracts, and this is also true for investors. I see investor clients all the time who've got contracts they've obtained from some seminar or from some guru or online. Use the TREC contracts. These are very good contracts.
And they are available to the public.
Yes.
Exactly.
Yes.
That's good information.
And again, if you need a variation for some specialized investor transaction, wraparound also a subject to, for instance, subject to transaction.
Okay, let's mention that for a minute.
Because there's no addendum for that.
Because I know you also are a specialist with wraparound. And we kind of just glaze over wraparound. We teach the definition, but I know years back it was important to know a wraparound because you could wrap around the very low interest rate. Well, interest rates today are so much lower than they were in the days that we did wraparounds. Right. But where do you see examples of using a wraparound mortgage in today's world? And how does it work? Tell our new people how a wraparound does work.
Well, a wraparound is exactly what it says. It wraps around an existing note and lien. So there's going to be a note secured by a deed of trust. This is a first lien note and a first lien deed of trust that exist right now. And for some reason, the buyer does not want to get third-party financing, or perhaps they can't. Maybe they're not eligible for it yet, for whatever reasons. And so they're going to wrap this existing note and lien by creating a new note, which is a wraparound note, which includes the balance of the existing note. So say the existing note is $100,000.
Right.
You could do a wraparound note for $125,000. And it's payable to the seller. The seller is then responsible for collecting those payments and then in turn making the payments to the underlying lender.
Exactly. But you have to have the lender's permission to do this.
In Texas, you have to send the lender a 7-day notice. Okay. That's not the same as asking permission.
You're right.
The typical deed of trust in Texas gives the lender the option, but not the obligation to accelerate if there's a title change. So what I'm seeing is that in a lot of wraparounds, so long as the underlying note continues to be fully performed,
Lender's
the
fine.
lender, they may not be fine with it. They might write a nasty letter or two, but they don't accelerate a performing note.
And that's the
More
important
often than not.
thing.
More often than not.
So tell our students what accelerating the note means.
Calling it due. If you look at paragraph 18 of the Fannie Mae deed of trust, there is a due on sale clause. That's what it's called. And it says that if the title or any interest in the property is transferred to a third party, the lender may, at its option, call the note due, entirely due and payable. So the lender is put to an election, a choice. Well, do I call this performing note due, which is otherwise, making us money?
Making us money.
Do I go through the expense of hiring attorneys, doing a foreclosure? Oftentimes they say no.
In today's world, probably not.
Yeah. And the other
They're
thing
okay.
where I don't see due on sale being much of a factor, I'm always asked about it, is when investors or real estate agents who are investors transfer a property in their name into their personal LLC for asset protection purposes.
Right.
I've never seen a lender accelerate that
Okay.
in 40 years.
Because it's still the same
Yeah,
person.
you might have to talk to them
moving into
about
an
it
entity.
and explain what you're
Would
doing.
you still need to send the 7-day notice?
Yes, but
to
that's
the
a
lender?
weird law because there's no penalty for not doing
No penalty for not doing
it. Yeah,
it.
you have to give, when you change title without letting an existing lender know, you have to give a 7-day notice both to the lender and to the buyer, who then can back out within that 7 days.
Okay.
But that's the only sanction. There's no penalty. If you don't do it, you go to jail. No, there's nothing like that.
This is what I love about our finance course, which is mandatory. But our new people getting a license, they must take finance. And you just learn all these wonderful things like that. But I can tell you, the people that are listening and watching today are saying, I have learned a lot. And you say it so distinctly. And you don't talk in circles, David. So you are a real pleasure to have.
It's been my
Thank
pleasure to
you.
be here. Thank you,
And
Rita.
one of our customers at Champion School of Real Estate.
It's always a pleasure to be back.
So I have one last question. With your years of experience, and I get this question myself a lot. In fact, I got it just this week in one of our classrooms when I walked in to say hello. What advice would you give to your younger self? Looking back, maybe some things that you would change in your professional life. What advice? Would you change anything?
Oh, we all would change a lot of things, whether we admit it or not. But here, I'll admit to this one. I would be more aggressive in investing on my own account. I've been offered the chance to invest with some clients, for instance, who are extraordinarily successful now. A license holder, whether you have a law license or a real estate license, you can invest with your clients, but it has to be done very, very carefully. So there's all kinds of disclosure you want to do
Sure.
and so forth and so on. So talk to your lawyer on that. But every once in a while, a deal will come up that you might want to participate in. Just be aware that if you have a license, you have certain obligations. You can't
Exactly.
just enter into that transaction as if you were anybody.
Okay. But that's good information, and that being that you might have invested more.
Yes, I was preoccupied with being a lawyer.
Yeah. Well, I want to mention one more time David's book, Real Estate Law and Asset Protection. And David Willis is right here in our own North Houston. He also has another office more centrally located in the Galleria location. And then I most definitely want to mention my book, which I'm hoping and believing that in volume 3, we'll have David in our book, where we take today's information that he gave us and just do some key points. And, but successful tendencies of real estate champions. We have wonderful superstars from all over the state of Texas, both commercial and residential, where these are their keys to success. They give us their day-to-day operational procedures and what they've done to continually stay in real estate or get the jump start. You can order it online as well as in the front office of your campuses. It's only $14.95. And then for sure, 30 days to success. Those of you that are brand new in the business and want to know how do I jumpstart my career, we give you 30 days of what to do every 30 days of your first being licensed or start today, and know how to get your career jumpstart. So this is by myself, along with a video that I tell you every day what to do in order to get your business started. So 30 days to success, successful tendencies of real estate champions, and then this wonderful book by David Willis, Real Estate Law and Asset Protection. David Willis, thank you so much. You have been
Thank you for having me.
You are such a smart guy with a great smile.
You make it very easy.
And we love your information today. Thank you for your business at Champion School of Real Estate, online, statewide, and all of our major metros in Texas. We appreciate your business so much.